Brother Masood. Thank you so much for being here today. He was kind enough to do the session for us online as well. Um, he had done the session in person at our Middle Ground Upland program. Let's do a quick introduction. Brother Masood has practiced law in California for nearly 20 years, counseling clients in business, corporate, and estate planning matters. Aside from practicing law, Masood serves as a part-time faculty at the Cal State University, Los Angeles, where he teaches business law in the Department of Finance. So welcome, Brother Masood. If you are sharing a presentation, I have given you the ability to do so, but you're welcome to address the audience first.
Thank you. Assalamu alaikum, everybody. Thank you for having me, Sister Zainab. Yeah, I did a presentation at the Middle Ground of last month, and alhamdulillah, it was people found it very beneficial. So thank you for having me here again. Hopefully, everybody will find something of benefit. Maybe some of the attendees already have an estate plan, but there's always, it's always useful to get additional information about it. So I'm happy to do that today, inshallah. So I do have a presentation. Let me just share it here. So now it's good. Okay, thank you. Bismillah. Okay, so basically I was asked last time to give a talk on what everybody should think about in terms of their assets, to think about what's important to know in terms of planning ahead of time. Obviously, there's a lot of things that happen when a person passes away in terms of their assets and property. So it's very important to think about that before it happens, because it becomes really difficult for the family to deal with not only grieving over the death of a loved one, but then on top of that, the logistics of how to transfer property and bank accounts and things like that. So the idea here is to plan ahead a little bit and try to make the process as smooth as possible for the family. So that's kind of the purpose of our talk today. So let me move to the next slide here. There we go. Okay. So why plan ahead? So one of the things, as I've already mentioned, is you want to make sure you know where your assets are going to go beforehand. So there are situations where there's different family dynamics, and there's sometimes differences between different members of the family. So you want to make sure that you don't create further division in the family by not planning ahead and not letting people know what's supposed to happen to your assets. Not only that, you want to safeguard the assets from and minimize the tax liability, minimize any other costs, particularly attorney costs, which can come up, and I'll talk about that a little later. You also want to make sure that your religious obligations are fulfilled in terms of Sharia and Islamic distribution of the assets. If you don't plan ahead, then the state of California has its own schedule of distribution that may not be what you wish. So it's important to think about that as well. And then, of course, as I've already mentioned already, is making it easy for your for your family to take possession of the assets after you passed away. So these are all some of the basic reasons why you want to think about this. Now, I know some people have a little bit of an aversion thinking about it, but it's very, very important. We see people all the time who unfortunately they pass away. They've made no planning for their families in terms of where their assets are supposed to go, and it just creates a big headache for everybody. So that's something that you want to think about. So what type of assets are there that exist that you have that need planning? Pretty much, assets that are in your name, specifically what are we call titled in your name. So real estate is the big one. Bank accounts, Some retirement accounts, they have beneficiaries. You want to make sure the correct beneficiaries are listed on your retirement accounts. Life insurance, if people have life insurance, then you want to make sure that the beneficiaries are listed on that. Healthcare, also there's debt that people have. So what you want to make sure, you're aware that, your family's aware that there's debt and what's supposed to happen to that. Some of the future planning that you may want to think about as well is burial, right? So some people, burial costs can be pretty expensive nowadays. So you may want to, purchase those plots now, so that maybe is just one less thing that your family has to think about, in terms of costs and logistics. Some people have a preference as to where they want to, stay, be buried. So they may want to take steps to do that. And then of course, end of life care. So this is obviously an important one. And I'm not sure, maybe I know Olive Center has, addressed some of these issues before in terms of end of life care, but if you have resources that you've maybe set aside or you've let your family know how to deal with that, that could be anything from having addressing your healthcare needs in terms of like, there's a terminal illness, what to do with, if somebody's on life support. How do you deal with that situation? Do you want the family to keep you on life support or not? These are all, not easy questions to think about, but important ones nonetheless, particularly for the family. It makes it a lot easier for the family if they know what you prefer. So these are some of the things that need planning. And so how should you plan? So what is the process that people should, embark on to be able to address some of these issues? So having something called an estate plan is very important. An estate plan typically consists of a few different legal instruments. One thing is called a living trust, having a will, power of attorney, burial instructions, as I mentioned, that addresses, burial, where to be buried. I forgot to put it on this list, but healthcare directive that deals with the healthcare issues, and then assignment of assets, which is where those assets are going to go after you pass away. So I'll talk about some of these instruments in a little bit more detail. So what is an estate? So we talked about having an estate plan. So what is that? What exactly is an estate? So estate is a legal term, and it refers to everything that comprises your net worth. So everything that you own, basically, real estate, jewelry, bank accounts, money in the bank, even your personal possessions, those are all considered your estate. So when we talk about estate planning, the idea is you're figuring out what's going to happen to your estate upon death. And that's really the important part here that everybody should be thinking about. So you're deciding what happens to your assets, your estate, while you're alive, instead of letting somebody else do it for you after you've passed away, right? Because if you wait for somebody to do it for you after you passed away, that probably means that there's going to be a court involved, and it's called a probate court, which I'll talk about as well in a little bit. So basically, estate planning is planning for the management disposal, of your estate while you're alive in order to ensure that your assets are properly distributed to your family, to your beneficiaries, and also while you minimize taxes and probate costs. So I don't have a slide here for the probate costs, but what happens is when a person dies without an estate plan. So let's say person has died, they have no will, they have no trust, they have no documentation at all whatsoever. What happens to them? What happens to their assets? So if they have no planning, then both spouses have passed away and the children now want to get possession of the assets, the children have to file something called a petition for probate. And a probate court is a special court, deals only with the assets of deceased. that it distributes the assets. So the court then has to appoint a what's called a testator, um, and that testator then has to do an accounting. So again, this is where planning ahead really helps your family, because now the family has to go back. They have to do an accounting of all of the deceased person's assets, what they own, what their bank accounts were, what their retirement accounts might have been, maybe life insurance policy, all of that stuff. They have to kind of figure out what they owned, and then they have to provide an accounting to the court. The court will then distribute the assets after determining who all of the beneficiaries are, who all of the children are, who are entitled to, who the surviving spouse might be, who's entitled to those assets. Once they make a proper determination, then the court will distribute those assets to those beneficiaries. Now, typically, a probate court, in order to file a petition for probate court, you have to hire a probate attorney. And the way probate attorneys are paid is they're not paid directly up front by the family. They are paid from the estate. So they actually are paid under California law by a percentage of the size of the estate. And there's a sliding scale. It's like the first 100,000 is 4%, the next several hundred thousand is a different percentage, and so on and so forth. There's a sliding scale. So approximately, if a person has $1 million estate, then the attorney is entitled to, the probate attorney is probably entitled to, we're talking maybe 40 or 50,000 potentially of the estate. So the way that the court issues the assets, there's a line item list of who gets what shares, and then guess who's on the bottom line is the probate attorney, who also gets a part of that share from the family. So that is ordered by the court to be paid. So it is pretty expensive amount of, it's a pretty expensive line item that is going to go to the probate attorney. So this process is very expensive. Sorry, so somebody question. Okay, sorry. I can't see everybody's faces, so I apologize. I'm trying to put up the I can't see if anybody's raising their hand or anything because of the way this.
We'll leave the questions towards the end, so no worries.
Oh, okay,
Yeah,
good. All right.
yeah, no worries.
Okay, good. Thank you. So, when a person dies without an estate plan, that's called dying intestate. So they die intestate. They have nothing at all, and that's when it becomes even more difficult. Now, there is a way to make it a little bit easier for the court to determine how the assets are distributed, and that is by having something called a will. Everybody's familiar with a will. The will is basically a set of instructions that directs where a person's assets are going to go. Now, just having a will is good, but not the best way to have an estate plan. Because just having a will means you still have to probate the will. The court will actually review the will, they'll make sure it's authentic. And the court will distribute the assets according to the will, but it does still take time, and you still have to hire a probate attorney to do that. So it's not the best option just to have a will. I know that a lot of Islamic organizations, they'll have like a sample will. It's an Islamic will, and the distributions are done according to Islamic Sharia, which is fine. But the problem is just having a will alone is not the best option, because you still have to go through probate. Now, what I mentioned previously in the previous slide was having something called a living trust. And the way let me see if this, so for some reason my slide, there we go. Okay. So a living trust is basically it's a legal instrument, and it allows you to transfer all of your assets to this instrument called a trust. And so what that means is on paper, you actually don't own anything. You transfer the ownership of the title of your house to the trust. You can transfer your bank accounts to the trust. you can even assign all of your personal belongings to the trust. And that's done through a legal document where you physically write, I'm transferring all of my assets to the trust. And so as I said, on paper, all of your assets are owned by this legal instrument called the trust. Now, when you create the trust, you become the trustee of the trust. So that means you have full control over it. You and your spouse have full control over it. And you are also the trustor, the creator of the trust. The trustee then designates certain beneficiaries. So in a sense, the trust acts like a will because it says after the passing of the two trustees, the assets will be distributed to, whoever those beneficiaries are, and you would list out those beneficiaries. And the instructions of the distribution can be Islamic, so they can follow the Sharia in terms of the share amounts, in terms of the which family members get what. So you are, you know, able to still do that in an Islamic way. Now, the reason why you set up a living trust, which is the best type of planning to have, for most people, um, it is because when you transfer all of your assets to the trust, technically that means on paper, as I said, you don't own anything. If you don't own anything and a person passes away, then there's nothing to probate. So it is, in a sense, kind of a workaround to the probate process. It allows you to transfer all of your assets to the living trust. And then the other thing is that you appoint what's called a successor trustee or successor trustees. Basically says when the two main trustees, both of them, the two spouses, pass away, that you appoint a successor trustee. Typically, it could be, family member or, adult child or whatnot. They then act as the successor trustee whose sole job is to distribute the assets to the intended beneficiaries. So a couple of benefits here to the trust over the probate process is that, as I've mentioned, it's much, it's following your intended, instructions. There's no probate court involved. There's no probate attorney that you have to hire. Also, it's a private document, so it stays with the family. One of the things that happens in probate court is because probate court is it's part of our court system. Everything that is filed in any kind of court is public record. So that means that you could have a nosy neighbor that wants to know what's going on in your family. They can go to the court website and do a name search and find all of the court documents that have been filed in a particular matter, and all of those issues would be public. So that's one of the other benefits of doing a trust, is that the trust is completely private. It's only between the family members. So and also the timeline is much shorter because the trust already owns the property. The new trustees that step in, they simply come in and they start distributing the assets as intended in the trust, as opposed to filing the petition in court and then waiting for the court to review it, and then the court has to appoint what's called an executor if there's a will, or a testator if there's no will. And then, that just takes a long time. And then finally, when the assets are distributed, it could be up to a year later. So, if you want to make any quick decisions if your family may want to, sell the house, or, maybe they needed the money from the bank accounts or whatever, that gets all of that gets delayed through the probate process. So one of the questions that comes up very often is, does an Islamic estate plan violate California law? And the answer to that question is it does not. It does not violate it does not violate California law. In fact, every state in the United States allows an individual to decide exactly how they want to distribute their assets. And that includes their religious obligations. So if they have particular religious belief and they want to exercise that religious belief in terms of how they distribute, and what shares and what amounts, they are fully entitled to do that. The court does not really the courts of our country don't really look at, who you're giving assets to, as long as it's the intended wish of the deceased. That's what they look at. Okay, if this is what the deceased person wanted, then that's how we're gonna, fulfill their desire and distribute the assets. Now, that aspect of just to give you an example of how important that is in our court system to distribute the assets according to the wishes of the deceased. In some and we're talking in some cases non-Muslim families, they will distribute, they'll cut out uh, they'll cut out a spouse. They won't give money to a spouse. They won't give money to a child that that they have. They'll say, no, I don't want to give money to this particular person. Or in some cases, they give, people will cut out their entire family from their will or their trust. And they'll give it instead, believe it or not, they'll give it to their pet bird. They actually have something called there's something called a pet trust. I know there's certain limitations to the pet trust, but just by way of an example, that actually would be enforceable. If somebody wanted to not give to their entire family and give instead to their pet, that would be something that the court would enforce. So, needless to say that the idea that you can give according to your Islamic beliefs is absolutely permissible and totally okay to do that. So a lot of people have hesitation. Oh, what if there's a problem with the court? What if it's not, it's going to create issues? So that's something that people often ask about. So just to kind of give you a quick overview on the type of trusts. So the most common type of trust is a living trust, or what's called a revocable trust. And the living trust is it's the reason why they call it a living trust is because and revocable is because the trust can be terminated and amended. It could be revised during your lifetime. So when I say revocable, it literally means it can be revoked at any time. So you always have full control over the assets of the living trust. If you wanted to take a house out and sell it, you could do that. You could, give away assets during your lifetime, even though it's in the living trust. Totally permissible to do that. There's no restrictions on that. The biggest benefit of the living trust is that, though, it does protect the family from having to go through probate, which is, very, very important, as I've mentioned. Another type of trust is something called an irrevocable trust. So an irrevocable trust is, as the name implies, not revocable. So it's more of a permanent type of structure. What that means is some people may have, additional assets, other rental properties. You can create a irrevocable trust that actually transfers it to that type of trust. The downside of that type of trust is that it becomes difficult to move those assets out of that trust once it's created. So it's a more permanent type of trust, and many people use that type of trust for different reasons. One of the reasons may be that they want to protect it from creditors. So the living trust, which is the most common, one thing that it does not provide is generally does not provide protection from creditors, meaning if there's somebody who sues you, or if there's debt, they come after the assets, that the revocable trust does not protect against creditors. The irrevocable trust does. It does protect against creditor claims, but as I mentioned, the downside is once you've put it into an irrevocable trust, you can't move it out of there. So if you wanted to, refinance the property maybe, or you wanted to sell the property and, use it for a business or give it just to some family members or something, you would not be able to do that with an irrevocable trust. So it does kind of, in a sense, segregate the assets and think of it as locked away. So that's some of the features of those trusts. So there's also something called a charitable remainder trust. I'm not going to go into all the different types of trusts. There's a lot of different types of trusts. This is just by example. This is some people, they have a lot of charity they give away, or they maybe have a property that they want to give to charity. They can do it through giving it to what's called a charitable remainder trust. So you can transfer it to a charitable remainder trust. It may be a rental property. And the benefit of a charitable remainder trust is that you can still generate, rental income. You can keep that rental income, um, and you can still use that property, but you've, during your lifetime, given away that property to a charity, and you get the full tax deduction for that, which you can take over several years. And you can still use the rental income, but what happens is when you pass away, it reverts, it goes directly to the charity, and then the charity can then sell it or do whatever they want with that property. So there's a few different things that you can do if if you want to think about charity as well. Um, some of the other aspects of estate planning that are important are having a durable power of attorney. So a durable power of attorney basically allows your spouse or your children or other family members to make legal and financial decisions for you in the event that you're incapacitated or you're have a health emergency, or you're maybe even just traveling. You can have somebody make those decisions for you if you need them to. Um, and this is very important. We had a family one time. There was a gentleman who was in a coma actually, and he was not married. He didn't have any children. He had siblings, and he had money in the bank account. He needed long-term care for his medical situation, but they couldn't access any of his bank accounts because they didn't have a power of attorney at the time when he had been in a coma. So that created some issues for them. Luckily, they found a power of attorney had drafted years ago in his personal documents, so they were able to use that. But it's something to think about. It's a very, very important document. Typically, people don't need it until it's until it's needed. Um, Advanced Healthcare Directive, it's a similar document, except this one just deals with healthcare decisions. So it provides instructions to the family as to how to deal with medical situation, particularly when there's um, a terminal illness, or if a person is on life support. It gives a lot of direction to the family, and many times the family then also gets into dispute. Some family members, they don't want to take the person off of life support. Other family members do, and so then it just creates allows for a little bit of direction for the family as to how you want to deal with that situation. Burial instructions, this is also important. Um, some people have very specific um, desires in terms of the way they're buried. They want maybe a certain imam to do the janazah prayer. Maybe they want to be buried at a particular cemetery. Maybe they've already purchased a plot, and the family needs to know that, because you don't want the family spending extra money to go out and buy a plot when maybe you've already purchased one. So that's all very important. And this is particularly important for people who may not have Muslim family members that are Muslim. There's been many, many cases that I've had, heard of where, there's a person who dies, and their family is not Muslim, and so they don't want to bury them in an Islamic burial. They do their own religious ceremony. In some cases, they'll even cremate the body. Um, and so it becomes very difficult. But if you have instructions, then it just lays everything out for the family as to how you want that done. Some people are very, very specific about burial. They want a particular family member maybe to lead the janazah. They want certain family members to be the ones who actually lower them into the grave. Certain imam to do the dua and stuff like that. So it's it's really a preference thing, but it does help the family. Um, you know, um, and then of course, if you have a business, either your own business, or if you have a family business, particularly if you have multiple family members that own the business, maybe it's brothers or uncles that own the business together, and maybe the deceased or maybe you own part of that business. That becomes very important to know where that business is going to go. Is it going to go to your children? Is it going to go to your spouse? Is it going to go to, the other family members who are running the business? Are they supposed to buy you out? Right? So many, many, many instances, unfortunately, happen where between family members where a person dies and then, the business is kind of still running, and then the family doesn't know what to do with the business, and then that creates a whole nother disaster, unfortunately, for the family because they end up fighting over the business. So that's another important thing to think about. um Okay, I know this font is a little small. I apologize. Hopefully you can read it. But so a couple of things that you want to think about. Maybe you already have an estate plan. It's a very common thing for people to have nowadays. So it's very possible many of the people who are here on this Zoom call already have an estate plan. So a couple of things if you already have an estate plan. So let your family know where the documents are, right? So I have a family client right now. It's a family. They, their father had passed away, and they can't locate the the trust documents. They know he has a trust. They know because the real estate was recorded into the trust, but they don't know where the documents are. So that's obviously a bit of a problem for them. So, they do have some photocopies, but still that can be an issue. So, um, and that's not an uncommon problem. So you want to make sure that if you have an estate plan, you have trust documents, let your family members know, particularly the people who are going to be acting as the trustees after you, the successor trustees. They should know where the documents are. Um, Make sure that you have an up to date estate plan, right? So if you have a durable power of attorney, maybe you don't have a durable power of attorney. Some people just do the trust, or they just do the will, and they don't have a durable power of attorney. So that's important to think about, because in the event of incapacity, that becomes a very, very important document to be able to give legal authority to a family member to, withdraw money from a bank account if money is needed to pay bills, right? All of that, is very important. Make sure your family knows about your medical wishes, burial wishes. Those are all things that if you have an estate plan, you may want to revisit those documents. Think about it. What maybe the situation has changed. So so you want to think about that. You also want to think about your bank accounts. If you have a trust, you want to make sure that the bank accounts are in the trust. Um, so that's very important, because if it's not in the trust, and if you have significant amount, let's say you've already set up the trust and you never retitled the bank account in the trust, and you have significant amount of money in the bank account, that bank account will have to go through probate. So it kind of defeats the purpose of having that trust set up, because the trust won't have ownership over the bank account, which means that they're very cautious, banks, often, especially when there's a lot of money in a bank account, to just release funds. The easiest thing for the bank to do is say, you know what, go get a court order, and then we'll release the funds to you. So that's important to think about how the bank accounts are titled. Um, Sometimes people, if you don't have an estate, or if you don't have an estate plan, or don't have a trust, at the very least, some people will sometimes put a trustworthy member of the family on the bank account. So at least they have access to the bank account. Um, you also want to make a list of your bank accounts and your retirement accounts for your family members, so that they know exactly what you own. Typically, if you have a trust, then there's usually a page in the trust that lists all of your assets, and that's done specifically for the purpose of letting your family know what you own, so that they can start distributing it and accessing those assets. Um, that includes, making a list of your retirement accounts, if you have a retirement account, 401k, IRA, pension plans, life insurance, all of those things. Maybe you bought life insurance years ago and the papers are in your stuff. It's important that your family, otherwise the family has to go and start hunting down those things. And, whatever money you spent on that life insurance now potentially may be for nothing because, the family has no knowledge of that you even owned a life insurance plan. Um, Passwords and logins. So if you have logins for credit cards, bank accounts, the electric company, gas company, your Netflix account, whatever it is, you want to make sure that those logins and passwords make a list of them again for your family members to access because that's going to make it very easy for them later to be able to, maybe they have to keep paying bills and close accounts and things like that. And rather than having to go into the branch and they can provide a lot of red tape sometimes, depending on who you're going to, which bank. Um, you want to make a list of your debts and liabilities, again, so that your family can pay those off. If you have any personal debts to people, then it's obviously Islamically it's a good idea, and just in general, a good idea that your family is aware of this. You can make a list and include it with your estate plan documents if you have those, or if you do have one day, so that way your family knows who to pay off from your assets. Burial instructions I've already mentioned. So again, just thinking about how you want that dealt with. And then I've already mentioned like assignment of business and interests. So that's all, to avoid dispute. And that's actually it. It's a nutshell. So I'll leave it open for questions at this point. So I'll let our host.
Thank you so much, Brother Masood. That was a very insightful talk. And yes, there's a lot of questions coming up your way. So here we go. The first one being, what if any items should not be in the trust?
So I'm okay. So let me understand the question. The question is, what is it in the chat, or let me?
Yes, it's in the chat. Are there any items that should not be in the trust?
Oh, it should not be in the trust. So
Mhm.
technically, what happens is when you make the trust, everything gets technically transferred to the trust. So not only titled assets like real estate,
Mhm.
but all your personal belongings as well, technically are supposed to be owned by the trust. And the reason for that is so that the estate, the trust owns it and then has power to distribute those assets. So technically everything's supposed to be in the trust.
Okay. If a person has a living trust, do they still need a will?
That's a very good question. So the answer to that is yes, you should still have a will. And the reason why you have a will, even though you have a trust, is sometimes, in the event that somebody, maybe you purchase another parcel of real estate, or you have some other asset, and it does not, particularly titled assets like real estate, doesn't get transferred into the trust, meaning let's say you bought an extra rental property and you forget to tell the escrow people to that you have a trust, and it never gets titled under the trust. When a person passes away, that asset will need to be probated because it's not owned by the trust. Now, yes, you'll have to go through that extra process of going through probate, but at least you have a will that instructs what happens to that property. Typically, when we have a will that drafted with the trust, it's called a pour over will. That will says everything that is not in the trust goes to the trust. So it makes the process a little bit more streamlined. And then it allows the court to say, okay, we're just going to move it into the trust. And then that's a done deal. Now the trustees can take over from there. So it's consider it like a backup document.
Mhm.
So where do we go to get a will, like write it down or something? Do we need to get a professional or notarized?
So that if I would suggest first having a trust
We have
before.
it.
Okay, so if you have a trust, then you should get a will done that's a pour over will that is connected to that trust. You probably will need, so whoever drafted your trust, maybe you can, let them know, and they can probably draft the will for you as well.
Thank
But
you.
I don't recommend drafting it on your own.
The next question is, will having a joint account with your adult child bypass the probate process?
Yes, it can bypass the probate process. If that's an asset you don't want to, maybe if you already have a trust and you don't have a trust and maybe your bank account is your main asset, then yes, you can put your child or other family member as a co-owner of the bank account, but you want to make sure that this is a trustworthy person, because once you put them on they have full access to those funds. So if you have an unscrupulous family member that you put on there, and then one day your bank account is down to zero, and then you go and report it to the bank, say, hey, I didn't authorize this person. They're not supposed to take the money out. The bank is going to say, well, they're a co-owner of the bank account. They have the legal authority to take out whatever they want. And there's nothing you can do about it legally. So you just want to make sure that the person you put on there is absolutely, somebody you trust to have access to those funds.
That's a tough decision sometimes. How much does a trust cost?
So typically the trust is drafted along with those other estate planning instruments, like the will, the durable power of attorney for the spouses, the healthcare directive, the burial instructions, and then if there's business assets, the business transfer, and then there's the real estate transfer documents. Typically, all of that will be in the 2,500 range, more or less. Obviously, if somebody has a larger estate and they have a lot of assets, then there's sometimes tax considerations that come in. So that can be a little bit trickier. So this depends on, but typically, most families, they fall within that range. There is something called an estate tax that is payable by the beneficiaries when they receive assets. There is a state tax exemption up to, it's roughly right now around $25 million between the two spouses. So the kids, let's say eventually both spouses pass away and the kids receive assets from their parents. The amount of money that they can receive tax-free, free of estate tax, is up to $25 million. So it's a pretty high amount. So it covers probably 99% of families will fall within that exemption amount. When it gets above that amount, that's when there's some other considerations that be thought about, and that's where it gets a little bit more.
If you need to update information in your trust, can you prepare a notarized document, and would that be valid until you redo your trust?
Yeah, absolutely. So it's called an amendment. If you want to update your trust, there's something called an amendment. And that's a valid legal document. It would just amend the portion that you want to update, the section. So maybe you want to change the successor trustees, or maybe you want to change the beneficiaries or whatnot. That is a very common thing to do. You would simply do an amendment, and that would be notarized, and that would be legally valid.
Along the same lines, how often or do you recommend updating the trust? Like you mentioned, many people do have their estate plan done, but what is your recommendation to relook at it after how many years, at least?
I would suggest, every couple years, it really sometimes depends on the family situation.
Mm,
Family member has passed away, then they definitely, especially if a spouse has passed away,
mhm.
and they had a trust together, then definitely you want to revisit that document, those set of documents, to update them, to change them. Maybe the property that's owned has changed. So I think that's definitely a time that you want to review and revise the documents. If there's a change, other family change, you know, um, people get married, then remarried, things like that. You definitely want to revisit those. But some people update like which charities they want to give to, things like that. So, maybe every few years, if there's no change in your family situation, then it should be fine, but every couple of years it's useful to just look at. But definitely after there's some kind of passing away in the family, it's a good idea to revisit those documents.
I'm going to make a little pitch to our Olivers here. Think of Olive when you're thinking charity. That would be great. So there's another one. Do these documents have to be completed by an attorney if it is not? If not, is notarization okay?
So there are like third-party services like LegalZoom and other organizations that kind of you can do them online and prepare the trust and the wills on. I don't know if they do will and trust, but I think there are some who do trust as well. So it's a good I don't know if it's a good alternative, but it is definitely an alternative. The problem is they're typically not lawyers who draft it. They're kind of an automated service. So if you have questions, if you want legal advice, if you want to figure out how to structure things maybe in a particular way, then especially if you want to do it Islamically, it's gonna be, I don't know if you're gonna find somebody to do that for you properly. So these are typically, a trust is not a document that you can kind of write on your own. There's supposed to be specific legal language in there for it to be identified and viewed as a trust. So ideally an attorney, should be doing it for you. It's not just that, just the notarization alone is just the one component. That's how it's signed. But it's not it's not enough, I think.
I was going to suggest mywasiya.com is a good resource for some information by Joe Bradford, if anyone's interested. So recently I was contacted by one of the Oliver families. They were trying to set up a conservatorship for their parent. And I know elder care law attorneys exist and whatnot. So can you expand on that? Is that is that a service that you yourself provide, or what should we do in that case when somebody has dementia or Alzheimer's or need that type of document done?
Yeah, so there's two ways to do it. And this is where the planning ahead becomes very useful, because once a person is what we call legally incapacitated, meaning they have severe dementia, or their cognitive function is declined to the point where they cannot write or they can't distinguish between things, then at that point you cannot get a power of attorney, because they can't sign it. So if you've planned ahead, then you would have had a power of attorney that would have given a family member the ability to make legal and financial decisions for that family member who has dementia or Alzheimer's or whatnot. So that becomes a very, very important document at that point. Now, let's say they never got a power of attorney. They don't have any estate planning documents. At that point, then you would have to apply for a conservatorship, which is what you mentioned. And a conservatorship is a process where a petition is filed by a family member with a court, and basically asking the court to make a particular person act as the conservator of this person with the cognitive disability, whether it's Alzheimer's or dementia, and to allow them to make all of the legal decisions. So essentially what happens is that the conservator, if it's approved by the court, will make them the conservator. So there's actual legal document that the judge signed, judge's orders, that appoints this person as the conservator. That conservator essentially steps into the shoes of that person, and now can sign documents, open up bank accounts, close bank accounts, do all of the things that are necessary for that person. And that becomes necessary because, like I mentioned, the bank or whatever institution will not give you access otherwise. They will actually require a court order for them to give you access. So that's an important thing to do, but if it's necessary, and in fact, sometimes it's the only thing you can do.
Right.
But in a way around that to avoid it can be costly because you have to hire an attorney to file a petition. And then there's accounting that has to be done as well, because as a
Mhm.
conservator, you have to provide accounting of what the assets are, what you're doing with the money, where it's going. And then the court, you may have to provide accounting to the court because it's a
Mhm.
court appointed conservator.
Mhm.
So as opposed to a power of attorney, which is more informal and allows, immediately appoints somebody to act on their behalf. So it's definitely a good idea to avoid the conservatorship, to have that power of attorney in place.
Right.
Uh,
And is that a service your law firm provides, just out of curiosity? Because sometimes, we think of only elder law attorneys, which are hard to find sometimes.
yeah.
Um,
Yeah, it is a specialized area. Our firm
okay.
doesn't handle conservatorships. It's somewhat specialized, and there's a lot of
Mm,
accounting and things like that that have to be done. So that's why there's typically attorneys that are specialized in either elder law or in
hmm.
conservative. Sometimes probate attorneys will do it.
Okay.
People who specialize in probate will do conservatorships because it
Hmm.
actually goes to the same court. The conservatorship actually goes to the probate court. So,
Oh,
so that's why they kind of, and the petition is the petition for conservatorship is a very similar petition as a petition for probate. So they
this
end
is
up,
good information to know because, like you said, we never know. There's another question in the chat about, will a durable power of attorney help the adult children if both the parents are incapacitated?
yes, definitely. It does help the adult children if they're incapacitated. So, in the event of, dementia or Alzheimer's or any of, or even in just being in the hospital, like maybe they can't physically, go to the bank. Then the durable power of attorney will certainly help allow, and it gives legal power to the children to act on their behalf. So, and you will have appointed the power of attorney who that person is. It could be typically it's the other spouse. And then if the other spouse can't act, then you will have appointed a secondary person, secondary agent after the other spouse. So, and if it's, if your spouse is already deceased, maybe then it would be an adult child or other family member, that obviously somebody you trust
Right.
to do.
I really appreciated your suggestion about helping your family, because I think that has been also something that has been brought up several times, especially during the pandemic. People lost loved ones and family members, and with all the current, virtualization of everything, passwords, accounts, if one
Yes.
spouse is taking care of all the bills, the other spouse has no idea. There's no paper trail. Back in the day, we would get
Yes.
bills in the mail. So I think that would be good to add to wherever your estate plan is, right? Having those things written down. Um,
Yes.
we we had Chaplain Sundus Kolaki once come in, and she suggested doing a death plan, just like people have a birthing plan of, how an offspring comes into this world, but how do you leave, and things like what you mentioned, having even a Google Doc or something where you're sharing it with family members just in case. And let's make this maybe a point of like learning, or maybe I can see if I can offer this as a workshop for our seniors to work into and look into with their families. Another question that came up, Brother Masood, is power of attorney, who should have it? Bank, healthcare provider, etc.
So ideally you want to give it to, you mean like physically? I'm assuming the
I'm
question
assuming physically, yes.
physically, yeah. So give it to you typically keep your documents at home in a
Mhm.
safe place. Let your family members know where it is. If if you want to scan a copy or photocopy it, you can give them a photocopy, or you can have more than one original if you need one. Keep one original and then maybe have a second duplicate original you can give to your family member. If it's an adult child, perhaps
Mhm.
that's easy for them.
Mhm.
Um, some people put some of these important documents in a locker, like a bank locker. I don't recommend that necessarily unless you've told your family where it is and they have easy access to that locker. You don't want to have a locker, put in a locker, and then, nobody can locate the locker, right? That would be another problem. So, or in a safe. Some people put in a safe, but again, if you put it in a safe, you want to be able to, have somebody have access to the safe. So you don't want to make it so, hide it away so well that nobody can get access to those documents.
Mhm. Is there an agency to help with cost if hiring attorney is not an option?
So that's where probably if you have like LegalZoom or some of the other organizations, they do have their online services are obviously much less than an attorney's. So that's a good alternative if that's the only way you can do it. Possibly legal aid. I'm not sure if
Yes.
will actually, do estate planning documents. They might. Um, I'm not aware. I don't know if they do or not, so I can't speak to it. But that's another possibility. But LegalZoom is for profit. They're not a nonprofit. They'll just prepare the online documents for you. The only thing is they won't know how to do it Islamically. Like if you want an Islamic
Mhm.
distribution, that's the only downside there.
Right. I think that one is where my wasiya might be helpful, maybe. So
Sure.
we could take maybe one more question. If anybody wants to speak up, unmute yourself and speak up.
Should I?
Yes, go for it.
My question is, maybe it is a basic question now, when this trust is drafted by an attorney, does it get attested if everything is mentioned over there? Who, how do we know that everything is there and it is
You said attested?
attested? I mean, to make it, that somebody has to be a witness or has to be notarized or
Yes.
whatever the terms are. I don't know, but this is a basic question that I would like to know.
Yes, and that's a good question. So the trust has to be notarized, and that you have an actual notary that comes in. When you sign it, the notary will stamp it and put his notary stamp on it and then sign it for the trust. For the will, when you sign the will, you actually need two witnesses that are what are called uninterested witnesses. Means that they're not beneficiaries and they're not related to you. So it could be the notary, it could be another neighbor or friend or somebody. So you would sign it in the presence of the two witnesses, and then the witnesses will sign it saying that they're attesting to having witnessed you sign that document.
So when we have a trust, why is there a need for a will? The will have the same information as the trust has.
So the will acts as a backup. So in the event that there's any assets that you may have that don't get transferred into the trust, then you need the will to provide the instructions to the probate court. And typically what we do is or what is often done is called a pour-over will. The will simply says everything that is not in the trust goes to the trust. So then it gets transferred to the trust, and then the trustee then can take control over the asset.
Okay. Thank you so much, Brother Masood. We're at time, and thank you everyone for attending today. It was great to see so many faces and attendees. And we hope that you took benefit from today's session, and don't leave it right here. That conversation continue in your homes and your families, because this is important. We have had several seniors who have had to deal with probate court because, again, when the pandemic hit, circumstances happened out of their control. So let's learn from those lessons and take this upon ourselves to make it happen. Make 2024 your year to have these conversations, inshallah. Okay, so thank you so much. Next week we have Sister Fiona doing a live cooking demo.
Olive Community Services is a 501c3 nonprofit organization based in Southern California that provides culturally appropriate services to seniors, their family, and the community. Through its physical and virtual interactive programs, Olive engages participants in a variety of ways that promotes health and well-being. To learn more about Olive Community Services, to get involved, or to make a donation, please visit www.olivecs.org or email info@olivecs.org. Be a change maker, and together, let's live, learn, and thrive.